Welcome to I Couldn't Help But Wonder Divorce Decoded, the podcast where we untangle the legal, emotional, and financial threads of modern family law, one story at a time. I'm Lorraine Silverman, and today we're exploring a question that comes up more than people think. What happens when you have a child but never got married? We don't all follow the same script. Not everyone gets married. Some people skip the wedding and dive straight into parenthood. But I couldn't help but wonder, when the relationship ends and there's no marriage certificate, what does that mean for custody? Because in New York, love may be simple, but custody never is. The story: the barista and the bookseller. Becca and Sam were never married. Becca managed a bookstore. Sam worked the espresso machine next door. Their romance was messy, passionate, imperfect. They had a daughter, Violet, and for the first few years, they made co-parenting work. No lawyers, no court, just handoffs and hope. But then Sam moved in with someone new, and suddenly, Becca was being told she couldn't have Violet on weekends anymore. No reason, no warning. And Becca found herself asking, if we were never married, do I still have rights? The legal breakdown. Custody for unmarried parents in New York. In New York, you do not need to be married to establish custody, but you do need a court order to protect your rights. Without a custody order or agreement, either parent can take the child and the other has little recourse. Here's how it works. Either parent can file a petition for custody in New York in family court. The court looks at the best interests of the child, which includes the same standard as married couples. For example, the court can look at relative fitness of the parents, stability, past performance, home environment, the ability to guide and nurture the children, each parent's ability to foster and facilitate a relationship with the other parent, untreated mental health of the parent, untreated alcohol or substance abuse issues of the parent, domestic violence, which is the only factor the court must consider, and the court is required to give credible allegations weighty consideration. You can request legal custody, decision-making authority over major decisions such as medical, educational, and religious decisions, physical custody, where the child lives, or both. If parentage hasn't been established at the time the petition is filed, the court will require that this be done first. A paternity petition is generally used to establish paternity for a father, such as a biological father. An order establishing paternity is called an order of filiation. A parentage petition may be used in other situations, such as when a child is born through assisted reproduction or surrogacy. An order establishing parentage is typically called a judgment of parentage. In many cases, parents assume informal agreements are enough, until they're not. A legal custody order protects your parenting time, outlines responsibilities, and gives you the right to make decisions if something changes down the road. The takeaway? Whether or not you are married, your role as a parent deserves protection. If you're raising a child and don't have a custody order in place, now is the time. Because custody is not about parenting schedules, it's about securing your voice in your child's life. Thanks for joining me for this episode of I Couldn't Help But Wonder Divorce Decoded. Next week, we'll break down what it really takes to file for child support, whether you're married, divorced, or never tied the knot. Until then, if you need help filing for custody or understanding your rights as an unmarried parent, visit thecdslawfirm.com for a confidential consultation, because you may not have worn the dress, but you still deserve the full protection of the law.